talk about trusts. What kind of trusts are prevalent? What is the most common form of trust that Indian promoters ask for or set up?
Trust is the most common form. Yes, this can be intermingled with limited liability partnerships because of tax pass-through, etc. But yes, ultimately trust structures, because it's an alter ego of your own will. In effect, I mean, I'm simplifying it, but you can probably do the same thing as you would want to do it under the will. I mean, you can pass on all that you want to pass on the way you want to pass on, as you had passed under your will, and during the lifetime control it as you would have otherwise controlled if the asset was on your name. And therefore, the trust structures. It also affords the pass-through taxabilities, tax benefits. Of course, it's nuanced because of Section 56 of the Income Tax Act and etc. But I think you can achieve the same level of control through the trust, but the Indian promoter, and by Indian promoter even you and me, would think that this belongs to me and now I'm putting in a trust and therefore I'm a trustee of the trust. So psychologically it always feels that you are distanced from your wealth. Legally you are not. Frankly, you are still in control. Only thing that the beneficial interest of that after your death may not be yours, but after your death nothing is yours. So it's about education. So I think the commonest form of structure is to put your asset into the trust, run the trust while you are alive the way you would want to. Of course, there is a law and you cannot run amok. There are some duties and liabilities of a trustee, but as a person who owns the asset, in any case, you're going to be truthful and faithful to your asset.
So say a client wants to invest overseas. What is the most common form of structures or ways in which they can do that?
Basically, tread with caution, because trusts abroad are, there are different kind of trusts. So if you are having trust in Jerseys and Guernsey, etc., which are all kosher trusts, but it is run by the trustees who are professionals, and then you govern by letters of wishes, which is not really that kosher, but it's in vogue in practice. There, the concept of distancing yourself from the wealth is much greater. So when you marry that with the fear of the Indian promoter, even in an Indian context where it's not so much, with a proposition that you are putting this wealth in trustees who are very expensive, who are at a time opaque. So we are doing a transaction where certain trusts have been formed and the person has died without will, and the trustees are not even looking at us today. We are, a law firm representing people, but they are not looking at the heirs now to establish who the heir, etc. So it's very difficult.
So Abhijit, what's your advice to private bankers? How should they raise this topic with their clients?
They need to know the technical aspect, which I'm sure they would have known in terms of the legal aspect and the financial aspect, tax aspect, little bit. Obviously, they'll be augmented by a team when they go into execution. But they should know, because life is not in a silo. So when I come and talk to you, if I don't know nothing about tax, I would be a little sterile in my because it's quite a multi-dimensional talk if I'm actually coming and explaining to you why. So they should know a little bit about those things. And they should know when to leave those things, because you cannot be a jack of all, and therefore at that point of time to say that we will have to bring in a lawyer, or we will have to bring in a tax guy, but this generally is an issue. I would say they should be a little less marketing oriented, especially to the Indian promoter. The Indian promoter is very wary of product pushing, and therefore they should really concentrate on value creation as opposed to product pushing, which is important, especially if you are talking to people who are mature enough to have created so much of wealth, and therefore we must trust or rather respect their intelligence, that they will see through this particular aspect. So that is the second part. The third part, as I said, that I think they need to understand and do some homework in terms of why and what of the fact pattern and customize it. The next part is the ease of execution. And what the Indian promoter is scared of, that when he moves from personal wealth to wealth in a trust, if he is going to inherit a lot of bureaucracy in managing the trust, or a lot of red tape, institutional interference, all those things, then they have to work on that part.
Abhijit, what's your opinion on trustee firms? Do you prefer independently owned trust firm over a bank firm?
Yeah, I would think so. There's always a difference. Because one is institutionalized, so in a sense that they are going to be, perpetual in their existence. They are going to be, I can't say after Lehman and perpetual in existence, but more perpetual than individual consultants. And also they will have the checks and balances. So there is going to be that much more, order to it. Individual trustees, on the other hand, have an advantage of understanding the need of the proposition and therefore becoming that much more nimble and at times can serve better. But it's two sides of the coin.
How is the Indian Trust Act different from, say, a Singapore or Hong Kong trust?
I can tell you one thing, the Indian Trust Act is very old. And therefore it's not going to be as vibrant as any of this newer jurisdiction. So it's very robust in terms of its jurisprudence, but very immobile in terms of newer concepts. Duties, some of the duties and liabilities of trustees are a bit more fiduciary in nature, bit more generic in nature. Ability, creation of beneficial interest, which are to unknown set of people gives tax consequences. If there are defined set of people, it's different. And so it's pretty. It's not a lot of places the concepts are subjective. On the other hand, you can do a lot of things under the Indian Trust Act because it's not prohibited, which might be prohibited elsewhere. So I would think that it's a very enabling act in terms of this practice area because you can pretty much do a lot of stuff under the trust.
Thank you very much.